All right, it's time for our first keynote presentation of the conference, an introduction to responsible behavior in outer space. Providing this presentation will be Ms. Jessica Talk. Jessica Talk is the Senior Space Multilateral Affairs Advisor for the Office of the Secretary of Defense Space Policy. She develops policy guidance, advice, and oversees planning, development, and operational implementation across the Department of Defense. She is also a graduate of the University of Nebraska College of Law. So over to you, Ms. Talk. Thank you.
Well, I'd like to start today off by thanking the United States Space Command and the United States Air Force Academy's Law, Technology, and Warfare Research Cell for inviting me to provide this morning's keynote address to kick off the second annual USSPACECOM Legal Conference. Thank you also to the organizers of the conference, Lieutenant Colonel Timothy Goines, Professor Jeffrey Biller, and Major Jeremy Grunert for all their assistance. I confess that these virtual conferences always give me a sense of trepidation, mostly because I never know how large my head is being portrayed on any given screen. I was told once after a conference that I was about 28 feet tall and filled the majority of the auditorium. May be slightly less intimidating here today. Before beginning my prepared remarks, I do want to congratulate USSPACECOM on their accomplishments with this conference. Having come from nearly a decade at the U.S. Strategic Command prior to moving to OSD Space Policy, I've been exceptionally pleased to see USSPACECOM ably take the mantle and expand the space-related sections of US Stratcom's Operational Law Conference. As fascinating as that was, it never seemed like quite enough time to discuss space when you had to combine the full nuclear triad, plus cyber, plus space. As you all well know, these conferences are incredibly helpful for bringing together the community of practitioners and keeping everyone informed of the latest developments in both operational law, policy, and academic thought. So thank you to all who decided to forego a few days at the Broadmoor to instead engage in thinking about the truly tough questions, such as what constitutes due regard or harmful interference. In fact, I am quite glad that I am not expected to answer those questions today. Before we get into the topic of norms, I want to give a short update on departmental space-related changes. As you all know, this last decade has been a time of unprecedented organizational change for the U.S. space defense enterprise, particularly with the establishment of the U.S. Space Force to organize, train, and equip, and the U.S. Space Command, which is responsible for the operations in the space area of responsibility. This reorganization also resulted in the creation of the Assistant Secretary of Defense, or ASD for short, for space policy, where I work, and which itself has also recently undergone a reorganization to take on the offices for space and missile defense, nuclear and CWMD policy, and cyber policy. But thanks to the fact that this position was specifically authorized by Congress, it is still called the ASD for Space Policy. Also developing over the last week, the DoD delivered the Classified National Defense Strategy, Nuclear Posture Review, and Missile Defense Review to Congress to accompany the delivery of the fiscal year 2023 budget. So be on the lookout for the unclassified versions because they will undoubtedly reshape the way we are organized and the way we operate, with implications for the space enterprise. Moving on, my remarks will first address the U.S. policy guidance regarding norms, the existing international legal framework, why the United States has chosen to pursue norms and non-legally binding measures instead of legally binding measures, and conclude with what the DoD is doing for norms development efforts domestically and internationally. So sometimes we hear analogies about outer space as the Wild West with no rules whatsoever. However, this analogy is simply incorrect, and worse yet, to draw that analogy out further, it implies that outer space could be a realm of vigilantes where might makes right. So from a policy perspective, a more accurate way of framing that environment is to recognize that despite nearly 70 years of human exploration and government activity in space, the rules governing operational conduct remain nascent. The development of rules for operating in the space environment are less advanced and more similar to the early era of steamships, cars, or airplanes. Unfortunately, the turning point for creating so-called, quote, rules of the road, end quote, for these modes of transport generally occurred after tragic losses of human life. When it comes to astronauts, cosmonauts, or taikonauts, it's easy to see the potential deleterious impacts of reckless and dangerous acts in LEO, such as the recent Russian ASAT test in November 2021, which endangered human spaceflight. But with non-human spaceflight related satellites, there's an additional complicating factor which we hear, which is satellites don't have mothers. So how do we create the impetus for rules where there may be no apparent immediate or direct loss of human life? This is one of the reasons why the president, in his interim national security strategic guidance in March of 2021, directed that the United States will lead in promoting shared norms and forge new agreements on space. Similarly, the December 2020 National Space Policy directs US government departments and agencies to lead the enhancement of safety, stability, security, and long-term sustainability in space by promoting a framework for responsible behavior in outer space, including the pursuit and effective implementation of best practices, standards, and norms of behavior. Additionally, the National Space Policy directs national security departments and agencies to communicate which space activities the United States considers desirable or irresponsible while promoting, demonstrating, and messaging responsible norms of behavior. This direction echoes guidance found in the previous 2010 National Space Policy, which has established a goal of strengthening stability in space through domestic and international measures to promote safe and responsible operations in space. The most recent policy guidance from December 2021, the United States Space Priorities Framework, continues this theme, acknowledging that as space activities evolve, the norms, rules, and principles that guide outer space activities must also evolve. The US Space Priorities Framework also states that the US will engage the international community to uphold and strengthen a rules-based international order for space, working with commercial industry, allies, and partners. The United States will promote the implementation of existing measures and lead in the development of new measures that contribute to the safety, stability, security, and long-term sustainability of space activities. So as you can see, or you've heard, there is a long-standing US national interest in promoting shared understandings, whether they are called norms of behavior, transparency and confidence building guiding measures, guidelines, best practices, standards, rules, or principles. In recognition of all this policy guidance, the DoD is working to foster normative behaviors by operating responsibly and transparently in order to promote the safety, stability, security, and long-term sustainability of space. Before we begin discussing norms in more detail, I do want to spend a moment to acknowledge the existing international legal framework. Every few years, we go through a spate of questions centered around the topic of whether the Outer Space Treaty and other space treaties should be modified. I think it's human nature to always ask, what's next? And the fact that the Outer Space Treaty and the other core treaties are well over half a century old makes them easy to conceptually dismiss as being outdated. But the fact that these visionary documents have endured through today is astonishing. Rather than perilously attempt to open up these well-settled treaties for modification, I believe there is a fairly widespread recognition, at least in the American and legal and legislative landscape, that most of the perceived issues stem from commercial perspectives and can largely be solved through national regulatory means. That being said, the United States is consistently clear in our policy and associated statements that international law, including the law of armed conflict, applies to activities in outer space to include military activity. In particular, 1, the Charter of the United Nations, 2, the Treaty on the Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies, or more popularly known as the Outer Space Treaty of 1967. 3, the Agreement on the Rescue of Astronauts, the Return of Astronauts, and the Return of Objects Launched into Outer Space of 1968. 4, the Convention on the International Liability for Damage Caused by Space Objects of 1972. 5, the Convention on Registration of Objects Launched into Outer Space of 1975, and most recently, 6, the Constitution and Convention of the International Telecommunication Union of 1992, all which provide the foundation of the space international legal framework for outer space and have served the states parties well for many decades. The United States believes that these parties continue to serve the national interest of the United States, other space actors, and the international community as a whole, and it is well accepted that the Outer Space Treaty is one of the most enduring and well-respected treaties in the practice of states. For example, despite being technologically able to do so for decades, every party to the treaty has adhered to the commitment not to place nuclear weapons or weapons of mass destruction in space, install such weapons on celestial bodies, or station such weapons in outer space or in any other manner. And this adherence has guaranteed over half a decade of peace in space. Moreover, the United States is proud to serve as one of the depositories for 3 of these treaties: the Outer Space Treaty, the Return and Rescue Agreement, and the Liability Convention. In lieu of amending any of them, the United States would welcome further adherence to these treaties and hope that these states which have not yet become party to these treaties do so and fully implement the obligations therein. So why norms? And honestly, what do we mean by norms? If we're satisfied that the existing legal framework with this existing legal framework and believe that national regulatory actions can adequately address upcoming commercial issues, then why have our national policymakers pushed so hard for non-legally binding measures, these norms, rules, principles, and guidelines? Given that this audience today is mostly lawyers, I can imagine that most of you are probably already shuddering after my earlier recitation of policy with the use of the word norms. In recognition of that discomfort, I'll take a quick moment to clarify this concept of norms. In this discussion, I have deliberately conflated the term norms with rules of the road, principles, guidelines, transparency, and confidence building measures, and all the other vernacular uses that do not implicate customary international law. However, the hope is that eventually these non-legally binding measures could take on the characteristics of what the legal community calls norms, that is, behaviors accepted and recognized by the international community as a general and consistent practice of states done out of a sense of legal obligation from which there is no derogation, allowing them to potentially form the basis for customary international law, or perhaps even forming the basis of future black letter legally binding measures. However, through the rest of this discussion, I will continue to use the term norms in a colloquial manner. Now, in our estimation, voluntary, non-legally binding norms, rules, and principles of responsible state behavior with respect to outer space can reduce risks to international peace, security, and stability by playing an important role in increasing predictability, enhancing operational safety, and reducing risks of misperception, and thus contributing to the prevention of conflict. Norms, also known as transparency and confidence building measures, or TCBMs, are an important means by which governments can address challenges and share information with the aim of creating mutual understanding and reducing tensions. Effective TCBMs can reduce or even eliminate misunderstandings, mistrust, and miscalculations with regard to the activities and intentions of states in outer space. The United States believes it is possible to reduce the risk of conflict in outer space by cooperating in the development and implementation of voluntary, non-legally binding norms of responsible state behavior with respect to outer space that strengthen the stability and security of the outer space environment. States should examine and develop ideas for responsible behaviors that would maintain outer space as a safe, stable, secure, and sustainable environment. The United States believes that there are many advantages to focusing on voluntary, non-legally binding norms of responsible behavior with respect to outer space. Among these advantages are: 1, a bottom-up approach based on technical and operational best practices for space operations and shared understanding, builds a more durable confidence among nations rather than politically sensitive top-down approaches. 2, the ability to adapt quickly to changing circumstances or technology. And 3, to allow new and novel uses of space to be explored. And 4, to allow civil and commercial operators to have more of a voice in their development. This view does not mean that states should cease engaging on and discussing space security issues at the Conference of Disarmament or other international fora, which generally focus on legally binding initiatives. Rather, taken progressively, discussions on security-related TCBMs could be a first step to addressing mistrust arising from misunderstandings between states. As such, TCBMs and norms, rules, and principles may lay the foundation for arrangements and agreements on outer space in the future. The United States reaffirms that the norms, rules, or principles of responsible behavior that are subject to multilateral discussions do not replace or alter the states' obligations or rights under international law, but rather provide additional specific considerations on what constitutes responsible space behavior related to outer space. Next, I'll quickly contrast the non-legally binding norms approach with, for example, the current problems inherent in a legally binding treaty approach. For the United States, entering into legally binding treaties with respect to space will be exceptionally difficult for multiple reasons. That is not to say that the United States is against legally binding measures. The United States has long held that it will consider arms control proposals that are equitable, verifiable, and enhance US national security. However, there are no current proposals which exist that meet these criteria. Why? Well, to take a look at the threat environment, some states are developing, operationalizing, the joys of networked homes. So to take a look at the threat environment, some states are developing, operationalizing, and stockpiling a variety of anti-satellite capabilities that could be used to, or have the potential to deny, disrupt, degrade, or destroy civil, commercial, or national space security capabilities and services. Some of these anti-satellite capabilities could be used to deny or disrupt space services temporarily, while others are designed to permanently degrade or destroy satellites. So these capabilities lead us to the question of definitional issues. Many of these space capabilities and technologies are inherently dual use, or sometimes called dual purpose, which presents both practical and conceptual problems when attempting to identify and respond to potential threats. Distinguishing between the civil, commercial, and/or national security uses of potential space systems, combined with the challenge of discerning the operator's intent, make it extremely difficult to craft a meaningful weapon of what constitutes an anti-satellite weapon. The way these systems are operated will be an important consideration in whether states perceive a threat from them. If the pattern of life for a satellite, for example, is consistent with its stated intent, then there will likely be less concern about its operations. However, even if a system is operated in ways consistent with the typical pattern of life for its stated mission, operating in a relatively transparent manner, or limiting its proximity operations to those requesting support, well, even then, such a system may still be perceived as a threat. Without a credible definition of a space weapon, one that is not immediately undercut by problems with verifiability or issues with subjectivity, creating any sort of legally binding ban on a particular technology would be difficult, if not impossible. Second, and equally as important, are ongoing trust issues between states. Effective arms control requires countries to fully comply with arms control obligations and commitments that they have undertaken. Many concerns relating to compliance involve matters of interpretation, as previously discussed. Furthermore, some states often attempt to conceal activities that is inconsistent with their obligations or commitments, and some are able to do so with a thoroughness and sophistication that can make it difficult to pierce the veil of denial and deception. While the United States and the majority of other participating states involved in arms control, non-proliferation, and disarmament agreements and commitments are implementing these obligations and commitments and have indicated their intention to continue doing so, the United States Annual Adherence to and Compliance with Arms Control, Non-Proliferation and Disarmament Agreements and Commitments report makes it clear that compliance concerns, and in some cases, treaty violations, and actions determined to be inconsistent with political commitments exist, involving a relatively small number of states. Compliance concerns, treaty violations, and inconsistent actions negatively impact trust in these states' fulfillment of existing obligations under the international legal framework and raises alarms regarding potential hypocrisy in fulfilling any new obligation that may be undertaken. Thus, the current lack of trust between some states is a significant factor in moving to that non-legally binding approach, and one centered on credible and verifiable TCBMs, which can better contribute to the trust building necessary for the ongoing promotion of peace, security, and disarmament. So after laying down this national policy, the legal framework, the rationale behind why the United States has chosen to pursue norms instead of legally binding measures, we'll conclude with what the DoD is doing for norms development. We all recognize that outer space is a challenging place to create norms. Space is an incredibly complex environment controlled by laws of physics that define motion in space very differently than motion on Earth. There are other competing factors. For example, the relatively recent and significant increase in the diversity of actors in space, the speed of technological change, economic and technological reliance upon the benefits from space, and the ongoing development of and threat from counter space capabilities all result in an ever-increasing risk of miscommunication, misinterpretation, and miscalculation. That being said, because the DoD is one of the primary space operators for the United States government, DoD plays a significant role in the US government's observation and demonstration of responsible space behaviors. DoD policies and practices often serve as the basis for international measures, and DoD strives to model responsible behavior through our routine conduct of space operations. Through our operators, such as USSPACECOM, we work carefully to ensure that our space operations are consistent with national policy guidance, as well as relevant domestic and international law, including the inherent right of self-defense. One of the key examples I would like to highlight is DoD's conformity with both domestic and international best practices regarding the mitigation of space debris, which you'll also hear about in a panel later this afternoon. Domestically, DoD best practices served as a source of the more rigorous debris mitigation standards adopted in the November 2019 US government orbital debris mitigation standards. Those standard practices seek to ensure that all US government operators are aware of and mitigate risks in routine space operations, such as reducing the amount of anticipated debris created during launch or reducing the risk of human casualties below a certain threshold during spacecraft re-entry into the atmosphere. Internationally, the DoD is following two premier intergovernmental sets of best practices with regard to space debris: the 2007 Space Debris Mitigation Guidelines of the United Nations Committee on the Peaceful Uses of Outer Space, and the June 2021 Space Debris Mitigation Guidelines of the Interagency Space Debris Coordination Committee. The DoD's long history of operational expertise and ongoing commitment to long-term sustainability and the stewardship of the space environment has also allowed for the department's participation in United Nations space-related committees. DoD participates in close coordination with our State Department. In fact, DoD provided one of the lead US delegates to the negotiations in the Committee on the Peaceful Use of Space that can produce the 2019 guidelines for the long-term sustainability of outer space activities. This involvement ensured consistency with DoD practices and greatly facilitated implementation of those guidelines. For example, formalizing the regular and routine sharing of space situational awareness on the orbital parameters of outer space objects and potential orbital conjunctions, which the DoD disseminates through USSPACECOM and the US Space Force's 18th Space Control Squadron. Most recently, DoD supported the U.S. Department of State's drafting of the U.S. National Submission in response to the 2020 United Nations General Assembly resolution on reducing space threats through norms, rules, and principles of responsible behavior. This resolution called for countries to, quote, study existing and potential threats and security risks to space systems, characterize actions and activities that could be considered responsible, irresponsible, or threatening, and their potential impact on international security, and share their ideas on the further development and implementation of norms, rules, and principles of responsible behaviors, and on the reduction of the risks of misunderstanding and miscalculations, end quote. This ongoing space security initiative, spearheaded by the United Kingdom, has culminated in a highly supported UN open-ended working group on reducing space threats, or OEWG, expected to make later this year and into 2023, with an anticipated final report detailing shared understandings of the legal framework, space threats, and potential responsible behaviors intended to reduce the risk of conflict extending to space. DoD will be an integral part of the US delegation to this OEWG, and I'm especially pleased to see that the primary drafter of that initiative will be speaking on a panel today after lunch. Speaking of drafting the US national submission to the Reducing Threats Resolution, our national submission included the conclusions of an internal DoD effort to determine whether there were any long-standing operational practices which could help reduce the risks of misunderstanding and inadvertent escalation. In July 2021, the Secretary of Defense signed a memorandum to DoD leadership that outlined guidance for DoD space operations in the form of 5 key tenets of responsible behavior in space. That guidance provided a clear and transparent statement of how all department components will operate in space during normal circumstances. The tenets direct DoD space operators to 1, operate in, from, to, and through space with due regard to others and in a professional manner. 2, limit the generation of long-lived space debris. 3, avoid the creation of harmful interference. 4, maintain safe separation and safe trajectory. And finally, communicate and make notifications to enhance the safety and stability of the domain. The Secretary's tenets were an important first step, but there is more work to be done. USSPACECOM continues to develop guidance regarding these tenets and specific behaviors for DoD operations in the space area of responsibility for use in shaping interagency and international discussions regarding responsible behaviors where appropriate. Note that these tenets and the specific behaviors are strictly limited to the activities of the DoD. In no way are we trying to impose our own rules upon other governmental or private sector space operators, but we do recognize that as one of the world's most experienced and largest space operators, and as a military organization, we have a special responsibility to articulate what we mean by responsible behavior and to reflect those values in our daily operations. So as you can see, the DoD has been a regular contributor to several multilateral fora regarding norms due to our longstanding expertise in conducting space operations. We have incrementally built common understandings among space operators about shared interests in space and explored what constitutes responsible behaviors in a shared domain. It is our expectation that together we can contribute our ideas, learn from other international space operators, and develop common understandings about space operations that can reduce the risk of misunderstanding and miscalculation while increasing stability and security in the domain. So in summation, despite nearly 7 decades of human exploration and activity in space, the rules governing conduct remain a work in progress. However, the world's growing dependence on space-based systems and technologies and the information they provide requires collaborative efforts to address space threats, whether natural or man-made. Building shared understandings among nations and space operators is critical for identifying what constitutes responsible behavior and conversely, irresponsible behavior. In the complex space environment, which features an ever-increasing risk of miscommunication, misinterpretation, and miscalculation, the DoD recognizes the importance of international cooperation, communication, transparency, and shared commitments by countries towards common goals, such as the long-term sustainability of space. Because of this recognition, the United States government has strengthened its effort to lead and sustain a stable and open international system with universal values and aspirations conducive to US interests, such as the creation of norms of behavior in space which are credible and verifiable. In the interim, the DoD continues to foster normative behaviors by operating responsibly and transparently in order to promote the safety, stability, security, and long-term sustainability of space. Over the next 2 days, several of the panels will dive deeply into the topics I've merely touched upon here, from due regard, limiting space debris, the limits of soft law and customary international law, what constitutes harmful interference, space traffic coordination, and even on-orbit threats. These are all deeply timely and complex questions that are relevant right now, and I truly look forward to what is guaranteed to be productive discussions and each of your unique perspectives. Thank you for your time and attention.
Thank you very much, Ms. Talk, for those remarks. I think that provides a very nice framework for the discussions that are going to follow throughout the remainder of this conference. We do have time, plenty of time for questions. So a quick note on how we're going to do question and answer. If you are on the floor here, please just raise your hand and one of our cadets will provide a microphone to you to ask those questions. Additionally, we will have some questions that are coming in from those who are attending virtually. So I'll go ahead and turn it over to Major Gruner to start with some of the question and answer from our virtual attendees.
Great, thank you so much, Jeff, and thank you, Ms. Talk, for a wonderful presentation. Thank you so much. We have a number of questions that have come into the chat box, ma'am, and so I just wanted to start with a couple of these while our live audience considers their own questions. First question is from Mr. Mark Meyer, and he asks, how do you integrate the general space law treaties and the long-term sustainability guidelines in national space laws?
So that's partially a question for our regulatory colleagues to some extent. You know, national space, I'm thinking about in particular, the registration convention, right? And that is one of the things that the United States government does for everyone because of the jurisdiction issues with who launches, who is US, what constitutes US satellites, et cetera. I suppose that one, there's a number of different ways that we do put these into both legal domestic law as well as into just practice and implementation in general. And so there are a number of different ways that these things are essentially handled. Again, back to the registration practices. So interestingly enough, there is no real law that says that we must register, right? It is just the registration convention. And so the people dealing with that, essentially the State Department and all of the regulatory agencies to include the DoD and NASA, have gone through and worked on implementation guidance. So standards of operating procedures that we particularly use, but aren't necessarily promulgated through domestic law, for example. Other things such as the LTS guidelines, they are kind of done in a piecemeal fashion, right? So they are implemented by each of the agencies as they see fit, as well as, for example, with the Department of Defense, the SSA sharing. So one of the key guidelines is sharing orbital information. Well, as the Department of Defense, we are not just simply allowed to give that information away because of the Anti-Deficiency Act. That being said, Congress has seen fit to put out a piece of legislation that essentially says that we can provide this information for free to external entities given a certain set of conditions. Those kinds of conditions are things that we actually try to front load into the LTS guidelines. As I mentioned a little bit earlier, I said the LTS guidelines, and many of these guidelines are actually derived from practices done by the US government to include the DoD. And so, for example, we did certainly push SSA sharing orbital information, sharing contact information between space operators, those types of policy, regulatory, and operational guidelines. So those were between us, NASA, State Department, and several of the other organizations that deal with that. But for regulatory issues, that is a question that is a little bit more better addressed to my regulatory partners in the other agencies.
Thank you. Thank you very much for that. That was really interesting. My name's Tam Jennings. I'm from the UK. And I just got a quick question about, you did mention that gaining sort of international consensus is very difficult. And I'm reminded that the Outer Space Treaty was signed at the height of the Cold War, when similarly international relations could be said to have been strained. But I also note that not so many people were involved in space at that time, so there weren't as many voices to try and get to agree. I'm just wondering whether if as we push forward trying to gain international consensus, do you think we're better focusing on the positive rather than the negative? And by that I mean getting people to agree positively what good looks like rather than trying getting people to agree what bad looks like. So what's responsible rather than what's irresponsible? What's your view on that? Thank you.
Yeah, I absolutely agree. And so what I would say is in my view, and so I have a kind of unique view, and I'm actually very lucky as part of the Department of Defense to be part of the US delegations to both the security side, so the Multilateral Disarmament Forum, that is for the Conference of Disarmament, UN First Committee, and the security side, while also sitting on the US delegations that go to COPUOS, the Committee of the Peaceful Uses of Space. And I think a really easy way to see that just work out in practice is the Conference on Disarmament and the security relations. They've essentially been deadlocked for years, for 30 years going on now. Recently, we were in a discussion with a lot of other international partners, and somebody said, this just hasn't worked for 30 years. What are we going to do about it? We have to make movement. But I think what our disarmament colleagues, who I would say focus on the more negative side of things, don't see is actually how much work is done in the other fora in multilateral venues, such as UN COPUOS. So for example, and I spoke about them very, very briefly, but there is a joy and a benefit from starting from technical and operational practices and behaviors, right? Things that we do think are responsible, things that we believe are, technically devoid of the politicization to some extent. Those things that we agree on, the things that are positive, such as space environment, however positive you would think space debris rather would be. But those are things that we've eventually come to agreement on, and that is in the UN COPUOS fora. So you see the LTS guidelines, 10 years of fighting, 10 years of people talking through the technical underpinnings of things. And so those are really coming to consensus on those, having so many countries come together. And I mean, these are countries that we don't have, usual relationships with, for example, or rather great relationships with. These are the Russias, the Chinas, the Iran. We are able to agree in UN COPUOS on things that are important to space, and it is because of that positivity to some extent. So I truly do believe that this is a great place to start, which is to think about what constitutes responsible behaviors, because that in turn, that positivity gives us an idea of what conversely may constitute irresponsible behaviors.
Thank you, ma'am. Another question from the virtual audience. I'll start with one that I'm taking them in order, but I'll start with one that's maybe a little controversial. So completely understand if you're unable to answer this. Does the Russian ASAT test, the Russian ASAT test that occurred last November, violate the Outer Space Treaty? Why or why not?
You know, we've really had a lot of discussions about this in the US government and what constitutes a violation. And honestly, this sounds terrible, but the United States, or rather the Outer Space Treaty, as many of you well know, is really a permissive document for the most part. There are parts that have explicit prohibitions, that is on WMD, that is on appropriation of basically declaring sovereignty over celestial bodies, or particular use of space, or excluding people from the use of space, and military maneuvers on the moon, etc. But really, that ASAT test was not exquisitely captured, right, in that treaty. And so I would be really hard pressed to say that it was a direct violation of it, not being one of the things that is expressly prohibited.
All right, seeing no additional questions from the live audience yet, let's move on for another virtual question. Ma'am, could you speak briefly to how the Artemis Accords are potentially establishing or shifting international norms, and how we can resolve the resulting tensions that are arising with Russia and China, especially when it comes to lunar-based development?
As part of the DoD, it's kind of an interesting story to talk about our sister agency, NASA. I personally am very, very proud of NASA for putting together the Artemis Accords and moving forward, finally, to some extent, on the return to the moon and moving on to do exploration towards Mars. That being said, and so those were personal views. That being said, on the DoD side, the Artemis Accords, we were very, 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 very important for us. Of course, it came through an interagency review process. And when we looked at it, we said, wow, this really is a document that sets expectations for how we will conduct, the United States will go forward and conduct the civil exploration for space. And so it reiterates quite a bit of the treaty, right? It reiterates what we think are good practices with regard to information sharing, and really that are safety based. But for the Department of Defense, it is a civil document, and only a civil document. So there are no security aspects to it.
Next virtual question is from Michael Listener. He asks, if norms being pursued by the US are not really norms, might it not be better to back off on that term, as using the term quote unquote norm will imply customary international law, even if it isn't expressly meant to become customary international law?
And I hate to say this, but this is just definitely one of those things that I have quit fighting my generals on. So as you can tell, for about the last 10 years, we've had a lot of folks out there saying that we need rules of responsible behavior in space, rules of the road, and they have used the word norm colloquially. And I think on the international front as well, I mean, even with the diplomats, we see people use the words norms quite liberally, without necessarily meaning the legal aspect of it. So I think that there's room to use that term a little bit loosely in the colloquial or layman sense. And as we start moving down the line, I think it is going to be really, really clear through state practice, et cetera, whether those things are becoming customary international law or not. And at that time, of course, then we can adjust our we can adjust our approach towards them or make it incredibly clear that where we would like them to sit on the spectrum of, soft law to hard law.
Wonderful, thank you, ma'am. Doubleheader question from Major Edwin Kissiel. He asks two interrelated questions. The first is referencing back to the Russian ASAT test, ma'am. Does the ASAT test cause harmful interference? And the follow-up to this question is, has there ever been an event where the consultation provision of the Outer Space Treaty has been triggered based on alleged harmful interference?
Well, I'm not going to, I might move a little on that determination, right? Harmful to some extent is still a question, right? I think we have said that it is dangerous, that it is reckless. Does it rise to the level of harmful interference? It's pretty interesting, but recently the Russians came out and said that it in fact was not harmful, and that they had specifically calculated it in a way that it would not be harmful, and then therefore it was not harmful and it did not threaten anybody. And so the problem with these things are that they are so subjective, right? And there is difficulty interpreting them, because you get into a situation where the states simply don't disagree. Now, we think that that is a disingenuous interpretation of it and are pushing back. And so you will see that there are many, many condemnations of it. The question is, and the question that I would ask back to the crowd here in the later panel that is specifically discussing harmful interference, is to ask whether it is or not, honestly. Happy to hear extra views on that. I think it's still, it's still something that we need to determine. And that has a big technical basis, but then also a huge subjective basis as well. Regarding the Article 9, or the consultation portion of the requirements of the Outer Space Treaty, to my mind, and maybe some in the room actually do know this, and I would love to hear it, honestly. I don't believe that the Article 9 consultation requirements have actually been invoked, either by a state choosing to act in space or by a state thinking that there may be potential harmful interference upcoming. Yes, I think we had heard that there may have been. I'm not sure after the 2007 Chinese ASAT test or not, but we haven't been able to, as far as I can tell, get to the bottom of that and find out. Certainly, it hasn't been invoked by the United States thus far.
Hello, it's me again. At the risk of holding the mic the whole time, so everyone will have to step in, otherwise I will literally do this all the time. I just had a question in my own mind about the speed of development. And I wonder whether, what's your sense of how quickly we're doing this, vice how quickly we should be doing this? And I've got in the back of my mind, when I think of the tenets that you set out, that the US have sort of set forth, a huge number of those are also things that relate to the behavior of commercial entities. And I do have a nagging doubt in my mind that if we're not quick enough to work out what good looks like, it'll be done for us by the commercial sector, who seem to be advancing in a much quicker way in terms of their certainly development of space technologies. And they seem to be exponentially increasing both their ambition and their level of technological capability at a rate that seems to be greater than that states can do, probably because states have so many more constraints upon them in terms of procurement, spending, etc. What's your view on the speed? Are we quick enough, and are we going to get left with a set of norms that the commercial sector have developed that we then end up having to follow?
That's an excellent question. So thank you. There are so many aspects to it, right? And And honestly, I wouldn't say that we are in conflict. The commercial, so from the United States perspective, we actually really encourage our commercial companies to go out, find those new, novel, and innovative or innovative methods of working, innovative ways of being in space. They're the ones that are basically taking mega constellations to the next level, but they're also, to some extent, really trying to be responsible as well. So there are several initiatives that I would say that I would point out here. And so, before saying, oh, we're going to be left behind, I would point out, the SIA, for example, came out a few years ago with principles of practice safe, responsible behavior in space. And this is actually before, the DoD or State Department, even before this responsible behaviors language started occurring in the disarmament fora. They had already come out with, a set of guidelines and practices. Similarly, we have our rendezvous and proximity operations set of communities, and they have started up a group called Confers. It's the Consortium for the Rendezvous and something or other execution of rendezvous operations, essentially, and it's about servicing. And so it is a consortium of a bunch of industry. Then they basically said, we've really got to figure out what a baseline is. We've really got to figure out what standard practices are so that we're all, not necessarily running wild out there and possibly causing issues, because they do actually see, our industry sees the benefit in being standardized, in having standardized practices. And so honestly, we take these folks, we've had confers on the US delegation to the Committee of Peaceful Uses of Outer Space. We've had SIA come along as well. We have a lot of these industry trade groups coming with us hand in hand to create a lot of these best practices that are at least on the safety side. On the security side, I'm kind of pragmatic about these things. I've worked in kind of the multilateral international affairs sort of realm for well over a decade, and my views on what constitutes quick have become, it's not going to be quick. I mean, for the most part, there is a difficulty in getting lots and lots of people, especially people who don't necessarily understand or know space, on the same page before agreeing to guidelines, rules, norms, etc. And I think, especially on the security area, you may not necessarily know bad behavior until you see it, right? And that has always been something that I think in general, all laws have to wrestle with. For the most part, laws for the use of traffic and cars didn't come along until people, truly started dying. Laws for airplanes, again, massive tragedies, loss of human life came about before people started going, oh, we should write rules of behavior for this and then turn them into laws. So to some extent, I always kind of think, hey, from a pragmatic sense, we're going to be necessarily behind on some of the things that we see that we don't necessarily like. That being said, as soon as we can tell, what constitutes a bad behavior, and other people become aware of it and also concerned by it, that's when we can start generating the momentum to move forward.
Hi, ma'am. Lieutenant Colonel Kirk from Pacific Air Force. So I had a question going back to the sort of self-serving interpretation from the Russians on the concept of harmful interference. What role has lawfare played as you've worked to develop some of these different areas in this arena?
I'll actually have you stand up and tell me a little bit more about what you mean by lawfare. So make this a bit more of
In,
an.
in this sense, specifically, and there's definitely broader definitions of lawfare, but I'm specifically speaking to the intentional interpretation and information of the law in a way that benefits or allows potential adversaries in the, in this area to basically engage in a way that they can say is in compliance with the existing law. And so, and yeah, I highlight the harmful interference interpretation from the Russian ASAT test as an example, potentially of trying to legitimize bad behavior through using these concepts. And have you seen that, and have you experienced that with other actors in this arena?
So a lot of the laws, especially with, the older outer space treaty, et cetera, are really, to some extent, I said, other than the express prohibitions, they are pretty subjective, right? What is out there can be fairly subjective. I would say with regard to specific quote unquote lawfare, we have seen in the best practices behavior and arena on the safety side, a lot of disarmament motivated types of guidelines, I would say, pushed by the Russians come into the picture. So for example, I guess another example, and this is again the Russians, not to pick on the Russians, but they are masters of procedure and do this a lot. While the guidelines were being negotiated, the long-term sustainability guidelines, one of the things that happened near the very end, so there had been this long deliberative process of focus groups and working groups and expert groups, and there were 4 different groups, and they, over a series of years winnowed and winnowed and winnowed, and they said, okay, here is a slate of things that we can agree upon, or that at least, that we think that we can start coming to agreement on. And, in the very, very end of it, there's a whole consensus procedure. Everybody said, oh, these are really good, we should discuss these. And all of a sudden, in the end, sort of near the end of the discussions, the Russians came in and said, hey, we've got 7 extra guidelines. And I think everybody was a bit confused, right? And everybody said, but we've gone through all of these processes, and suddenly at the very, very end, here's 7 extra guidelines that we have not, particularly, no one's really seen. They came to us whole cloth. We weren't entirely sure what to do with it. So, to some extent, with the spirit of Vienna, we attempted to come to a compromise, and we really looked, at the 7 guidelines that the Russians brought. And honestly, when we looked at them, we said, a majority of these are disarmament related, and a majority of these are disarmament related in disguise. And we said these will for sure prevent new and novel uses, possibly commercial uses. We don't know, a lot of the 7 guidelines, there just weren't state practices, they were not best practices by anybody at that point. And so we found it really, really hard put to try and agree to them. And in fact, they were not agreed. And that is that attempt, and I suppose you possibly could call it lawfare, or really just status quo for negotiating, was one of the things that honestly tanked the first round of the LTS guidelines. They were actually fully ready to be signed. The first set of 21 guidelines were ready to go in 2018, and the Russians said, well, our 7 guidelines aren't in there, so we're not going to agree to the LTS guidelines. And that was in 2018. And it was a serious blow to the committee. It was a serious blow because people had worked on this for 10 years, and so there was a lot of emotion around that. And luckily the next year we were able to come back a little fresher with a compromise to essentially say, you know what, we're going to go ahead with the LTS guidelines. We are going to implement them. And we think that implementation is the most important thing that is going to drive these guidelines forward. And you know what? When the Russians kind of took a look at it, they said, okay, well, you know, we've got our 7 unagreed guidelines, and these are still important to us. Maybe there's a chance in the future that we can bring them back. And so I think to some extent, you know, aside from them being what we would call disarmament guidelines and therefore not appropriate for that fora regardless, there is the spirit of compromise that says at least, okay, well, we can look at it again, right? But it was something, so again, that was one example of us just of international negotiations just being kind of tripped up by spurious interpretations or things that didn't necessarily fit. Hopefully that helps answer your questions.
Ma'am, Curtis McNeil, my question for you is, and it sort of plays off on our friend from the UK, as we wrote all of these things in the 60s and interpreted them through the 80s and 90s, they've all been based on state actors. And it's all been the launching state or the retrieving state or the state in which the corporation is incorporated when we apply it to companies. As corporations and other entities, not states, start participating more and more in space, how are we going to bring that forward when we get to things like a multinational corporation, which is using materials they bought in China to launch from somewhere in a French territory using Soviet, or I'm sorry, I'm old, Russian-based launch vehicles, and we transition to a multinational environment. And how do we handle things like flags of convenience that we've seen in the open seas and in the law on the open seas, where you've got a Panamanian satellite company that's launching on a Panamanian satellite, and Panama not only has no interest, but has no responsibility and takes no responsibility. And I'm picking Panama because they're a major flagger of vessels, not because I'm anti-Panama, okay? But as you go through this, how are we going to deal with that multinational corporation and that flag of convenience issue, particularly since all of our treaties and all of the responsibilities are based on state actors or a link to a state actor?
Yeah, you know, in fact, that's a fantastic question, and it has been one that has been a question through the ages. One of the neat, I would say, tricks of the Outer Space Treaty is that it does tie everything to a launching state, right? It ties all of our commercial actors to a launching state. But as you noted, that there can be, you know, multiple states that are involved with the launching, right? Procuring the launch, like who is actually launching the territories, et cetera. So this is actually one of the things that we're trying to prevent with the long-term sustainability guidelines, both prevent and encourage to some extent. So what we're trying to encourage is for people not to use flags of convenience. We do this by trying to capacity build, by trying to share our regulatory, you know, how the United States does it, how Canada does it, how basically everybody registers, you know, their commercial vessels. And so a lot of these that we're finding now, and you know, so this is a hot new topic, but for example, India or let me see, New Zealand, actually, if I recall correctly. New Zealand is one of those new launching states, and they're one that, you know, we are really pleased to work with because they have done such a great job trying to figure out what the rules really are. And when New Zealand launches something from the United States, they literally send over a piece of paper that says, hey, we're launching this, but do you accept the responsibility of being the launching state? And so, you know, we see in real time how the states are really trying to work out these practices. Really, we haven't had a lot of companies and organizations slip through those cracks yet, right? To find those jurisdictions of convenience, to find the flags of convenience. And actually, that's a huge part of why the implementation of the long-term sustainability guidelines is so important, is because it gives states an opportunity to have those discussions. There are not that many launching states, so you don't have that many launching options, right? And so the states now being able to talk to each other is a really, really great initiative that allows them to say, hey, wait a second, who does take the responsibility for this? Who does end up being the launching state? And I think we're going to see things like those cross waivers of liability, et cetera, start coming about as states figure out what the best practices really are. So a long way to say essentially that right now it's not an issue. We really truly hope that it doesn't become an issue, and we really are trying to head it off through essentially standardized international practice at the moment.
Okay, I think we have time for one more question. Please go ahead.
Can you hear me? Oh, thanks. As these processes get more, I guess, more important, identifying due regard, harmful interference, and you mentioned that states respect the prohibition of weapons of mass destruction in space. You note that there is no verification and compliance mechanism in the Outer Space Treaty. So I'm wondering how the Department of Defense is thinking about that. If you do identify behavior that you think violates one of these tenets, what are the processes, where do the data come from? How are they shared? How are they, how do you convince the actor and the other states parties that indeed you've identified harmful behavior?
Yeah, you know, that's of course the last question is the really thorny question, of course, right? This is one of those times where we, you know, I am fully aware that the Department of Defense is not going to be a trusted actor for most, right? Other people have no real reason to trust the Department of Defense or what we say when we say, oh, look, there's been bad behavior. Oh, look, what has, you know, look at these on orbit activities. And that's, you know, that is one of the reasons why we put our tenets out there to essentially say, this is how the Department of Defense is going to react. This is how the Department of Defense is going to operate in space. If you see us acting differently, you know, of course, let us know. We hope we're really not in contravention of our own tenets. We don't intend to be. Those are longstanding operational practices that we have. The question is, what are the practices that others have? And if it violates some sort of norm of behavior, or it is determined to be, at least by our own information, reckless, et cetera, I think what we don't want to have is a situation where you have two countries essentially with completely diverging views, right? I mean, it may happen regardless, but what we want to see, and what I think we're starting to see, is the rise of the tools that are allowing to address that. There is a rise of external SSA sharing external SSA information. So there is a commercial market for it now. You see folks like on our commercial side, like Leo Labs, like Exo Analytics, others who are able to take those telescopes, are able to take radars and go out and say, hey, look, this is what we saw. We are not part of the US government. Here is what we possibly think is truth data. Here is what we possibly think is happening in space. And I think you have that combining the slow rise of commercial SSA providers, as well as other SSA providers, right? For example, the EU has the EU SST, and forgive me, I don't quite remember the entire name. I think it's Space Surveillance and Tracking Initiative. They've gotten together to basically say, okay, well, we need an SSA, a way to verify and track space objects as well, both for national security and also civil uses. And so you're no longer, I think to some extent, just reliant on the United States, what the United States says, no longer necessarily just reliant on what Russia says. We don't know what their catalog says. We don't know what China's catalog is showing, but you can look at the United States and then maybe we can start to verify the things that we're seeing. Yeah, and so I'm reminded, you know, and I really hate this example, but I'm going to use it, of a few years ago when we saw what we called the on-orbit Russian nesting dolls, right? There's one satellite, it came up, and then all of a sudden it birthed another satellite, and then all of a sudden the third one came out and went pew. And we essentially said, whoa, we think that was a projectile. And so we started to say, hey guys, everybody, that was a projectile, and it was really difficult actually. And it's a lesson learned on our behalf that other people, we derived it entirely from what we thought was unclassified data, right? But it still required people to look at US unclassified data to verify that, to verify that example. So I think we're starting to see the rise today, again, of SSA sharing assets and others' ability to actually verify these things independently that will actually help a lot when we go forward and we're looking at responsible behaviors, as we're looking at what can be verified, what is credible. It does take a willingness to use data that's other than the United States to just make sure that this is, to some extent truthful and accurate, and that that violations or compliance are seen in orbit and as we go to orbit and to and from and through space. Thanks.
Great. Well, please, everybody, join me in a round of applause for Ms. Talk. A heartfelt appreciation for your willingness to answer so many questions and really be so candid with us about some very difficult issues. So thank you very much for your time. I do have a coveted second annual U.S. Space Command Legal Conference coin for you. Obviously, I cannot hand you this right now, but we will make sure to get that to you. So thank you again very much for your time and participation.
Thank you. I really appreciated the discussion and the really thoughtful questions.